Hi, my name is Lorena Sadie, and I am a bankruptcy attorney here in Atlanta, Georgia, and I cover all of the Northern District, and I've been doing this now for over 20 years. I am definitely a bankruptcy dinosaur, at least here in Georgia. So with that said, I just wanted to do this quick video about things that I see people or clients and other people's clients freaking out about they shouldn't freak out about. And I hope this video, if you are thinking about filing bankruptcy or you've just filed a bankruptcy, I really hope you watch it, and I hope it will decrease your level of anxiety because this can be a very nerve-wracking experience. Most of the folks I talk to have never filed bankruptcy before. They didn't think they would be in this position, and they're scared, and I get it. And so as bankruptcy attorneys, especially for those of us who've been doing this for decades, we know that, hey, this isn't a big deal. That's not a big deal. But clients don't. And so I try to remind my clients, like I have a rule. Before you're allowed to freak out, you have to talk to me first, because 99.9% of the things that you are going to get, notices, letters, whatnot, in bankruptcy court, they are non-freak-outable things. I wanted to do this just quick video and give you a couple of examples of things not to freak out about, panic, and think, oh my God, I'm done, everything's ruined, because people's brains will go boom, worst case scenario. And that's rarely the case. Bankruptcy is awesome. You have so many chances to fix boo-boos. It's great. So let's talk about it. So first thing is, understand that when your bankruptcy attorney files your case, sometimes, like in our firm's case, we may file, or I may, because I file all my cases personally. It's me. I'm the one that does it. When I'm filing cases, I may wait until the end of the day and file several cases at the same time. And when I do that, every once in a while, if I don't click in there to make sure I've paid the filing fee instantly, it may generate a deficiency notice, and it's annoying, but it's the way it is. And the court may send a deficiency notice out saying, hey, this fee wasn't paid. You have so many days to pay the fee, blah, 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 blah. But the truth is that the fee's already been paid, but that notice may go out. And so if the client gets it, they may be like, oh my God, I paid it. Why did I get this notice? And they start freaking out. Well, you don't need to freak out. I'm telling you not to freak out, because if you paid our office and signed up or whatnot, that fee's already been paid. But if you get a deficiency notice, by all means, reach out. And I'm happy always to confirm with my clients. I just confirm by email. Oh yeah, you're fine. Just throw it away. You're good. So no reason to panic, no reason to go off into the deep end thinking your attorney has stolen your money and they're in the Bahamas with your filing fee. It's not what happened. But anyway, again, not anything to panic about. Now, the other thing I have seen people really flip out about is at their 341 hearings. And yes, it's a court hearing. It's stressful, even though we're doing them by phone right now, which is great. Sometimes, let me give an example. If you didn't provide a copy of your taxes when you were supposed to, the trustees are supposed to have those 10 days before your hearing. And when you filed your case, actually before you filed your case, our firm already told you this is what we need. If you didn't have them at the time, we can still file your case without your taxes. I'm not a filing Nazi. I know somebody, they've got a garnishment, they've got this. I'm going to say, okay, but on your honor, I'm going to need those taxes ASAP, because when it comes time for your 341, if we don't have the taxes, a trustee may say, I'm going to reset this hearing until you get me the taxes. And so don't freak out and think that your case is gone, whatnot. You just need to get your taxes to your attorney so that they can get them to the trustee so your hearing can be held. So again, trustees reset hearings all the time. Not a big deal. And I had an incident come up, and the client assumed, oh my God, my hearing got reset. Does that mean my discharge date got extended out? She was a Chapter 7 client. And I'm like, oh, that is a good question. No, it doesn't. It doesn't extend it out. So if your 341 hearing gets reset, it does not extend out your discharge date. So it's not doing anything other than if you get a reset in a Chapter 7 case, it just means you have to call in. It's going to be 10, 15 minutes of your time. So that's it. So be happy. It's not like in the olden days when we had to drive to court. That was not fun if you had a reset. But in this case, it first of all, it's a phone call, and it's not going to have anything to do with your discharge date. So you're still going to get discharged at the same time. So it is very, very important though that you remember that, there's items that we're supposed to have. Now, sometimes folks file, and maybe there could be like in the pay stub you submitted, maybe you were missing a week or a month or something. And the trustee may reset the case and say, well, I'm going to reset this until I get this. Okay, that's fine. Because if you just get the document to us, we file it. And then the trustee, almost every trustee will then, we'll email it to them, upload it on their private portal. Trustee will say, okay, that's fine. The person's excused. You don't even have to call in, and we'll let you know that. But again, it's not going to do anything to your case. You're not in trouble. And they're not dismissing it. It just means, hey, we need this. So don't cause yourself a panic attack over something that you don't need to. Because again, 99.9% of the things that come up in bankruptcy court, nothing to freak out about. The other thing I see clients lose their minds about are they'll get a notice of transfer of claim. These are my Chapter 13 folks. And so you're chugging along your Chapter 13 case and you get a notice that your claim has been transferred to someone else. It doesn't mean that you now owe two people the debt. It just means that there's this company that they have bought the rights, or it's been transferred to them to just service the debt. There's nothing you need to do. There's nothing I need to do. It's just a notice because they need to put everyone a notice that, hey, now we're taking care of it. This is filed in the court. Your trustee knows about it. Nothing you need to do. Nothing you need to panic about. It's no additional cost or liability to you. It's just hey, by the way, this is what's going on. And remember, we get a copy of everything the court sends out. So you don't necessarily need to send me a copy of everything you receive because I already have it. Now, if you get something and you're confused and you want like, hey, I don't know what this means, I'll always tell clients, please take a picture and send it to me. Because if you send me a text or an email and say, hey, I got this letter in the mail and I don't know what it is, well, you could have gotten a lot of letters in the mail and I don't know which one it is. And I really, it's not a very good use of my time to pull an entire case document and go through every document that's been mailed to you trying to guess. So make it easy on everybody. Take a picture with your phone, send me that letter, whatever you're confused about, and then it's easy. I can tell my clients, oh yeah, that's just this or whatnot. The other document that we see folks lose their mind about, and we warn our clients, it's in the videos I send you prepping you for your hearing, it's in my emails, is the objections to confirmation. Again, this is a Chapter 13 case. Objections to confirmation. You do your 341 hearing and the trustee will announce, well, sometimes they'll announce objections, sometimes you'll just get them in the mail, but you'll eventually get them in the mail. Almost every case has objections. And it's, again, nothing to freak about. It just means the trustee is saying, here's the things that I want to see fixed by confirmation, which is your next court date, usually in a month, where the trustee is going to look to approve or deny your case. Okay, it just means when you get that hearing notice, if you're my client, I've already sent you, you've gotten a reminder. Usually the lady in my office, that's her job, is she goes through these and makes sure she can tell clients, I need this, I need this, I need this. She'll probably have already reached out to you. But if not, all you're doing is just scheduling a call so we can go through them to say, hey, I need proof you made your mortgage. Oh, hey, I need proof that your spouse that didn't file bankruptcy that's paying a car payment, I need to see proof of when that ends. So the court knows if you've got extra money coming into your case before you get out. Things like that, little things. But anyway, you don't need to panic about objections to confirmation. Same thing goes, believe it or not, if you get a creditor objection. Creditors object all the time. They'll file, oh, I object. I want, and the objection looks scary because at the end it says, and I want the court to dismiss this case. Okay. nothing is going to get done without there being a hearing on it. And when you see creditors filing these objections, a lot of times they're filing them because maybe they want us to adjust the plan to pay them more money. Maybe you underestimated what you owed them and they're really owed something else. And this is their way of saying, hey, we filed a claim in your case. This is what we're owed. So you need to fix it. And that way they're giving everyone a formal heads up, this needs to be fixed. So don't panic if you get a creditor objection to confirmation. Most of the time, there are things that we're just going to hammer out with them and you don't even need to do anything. But if you get one, don't panic. Remember, we get a copy of everything that gets filed in court. So that's something we're going to have to address anyway. The only thing that I always tell clients, yeah, you do need to make sure if you get this notice, you need to pay attention is if you did not pay your entire filing fee when you filed your case, which if you file a Chapter 7 bankruptcy, the whole filing fee is $338. If you did not pay $338 to file, you probably paid $78, which is an installment payment on that. If you get a deficiency notice that an installment payment hasn't been made, that means the payment for $130 and then the other payment for $130 because you have to make 2 installment payments. If you get a deficiency notice about that, you need to fix that quickly because if you don't resolve that notice, yes, your case gets dismissed. Chapter 13 bankruptcy, the filing fee is $313. If you did not pay $313 to file your case, and that's easy, go back and look at your emails, look at your receipt. That's easy. If you paid $78 or if you paid $313. If you did not pay the whole $313 and you get the deficiency notice that you owe the $117.50 on the installment, you need to get that payment paid ASAP. If you're one of my clients, you can easily go to my website, click on either Chapter 7 portal, Chapter 13 portal. I have a link. You can pay it online. Super easy. So yes, those notices, those are urgent. You need to pay attention to those. But other than that, most of the issues that come up in a bankruptcy case, yes, it's anxiety for clients. We get it because this is new to you. But before you start to have a panic attack, start flipping out, just ruining your own day, talk to your attorney. Send an email. Hey, this happened. Is it a big deal? Do I need to be concerned? And of course, we should be able to tell you quickly, no, not a big deal. It's fine. Go about your day. Because most of the notices you're going to get, they're not freak outable notices. But again, we understand that you've never done this before. You don't know what's going on. Get that. But as I always tell my clients, the reason you're paying us, you are retaining us, is so we can take on everything and we can tell you, oh, pay attention to this. Oh, okay, freak out about this, but don't freak out about that. That's our job. And we've been doing this over 20 years, at least my firm has, and that's what we're here for. So we know the ropes. Our goal is to just get our clients through this, get you the best possible result. And we want to try to cut down on your anxiety level. And I do realize that it's hard. Some people are just naturally anxious. And in one way, yes, I'm happy that some of my clients, they don't pay attention to anything. And that's not a good thing either. But we don't want you to have a lot of anxiety. So just make sure, when you're looking to file bankruptcy, have a conversation with your attorney. And I have some clients, they're very funny. They'll be like, look, I freak out about everything. And so I'm like, okay, well, you don't need to freak out about this. And I'll tell you if you need to freak out. And if I don't tell you to freak out, don't freak out. But just make sure, if you're thinking about filing for bankruptcy, you've never filed, best thing to do is educate yourself. For me, I've got my YouTube channel. I like to do a lot of videos. So, when I do consults, I tell my clients, my potential clients, I'm like, as cheesy as this sounds, go to YouTube. I have a lot of videos and it may give you some questions you want to ask me so that, you don't have anxiety later, because that's education is a wonderful thing. But anyway, if you have any questions about bankruptcy, at least here in Georgia, I'm always happy to answer questions, and my information is below.